Welcome back. Welcome back to Sustained Overruled. All right, let me share my screen. I can probably only go an hour tonight, you guys. So my throat hurts, okay? My throat hurts. I don't know. I doubt it's COVID. I've had COVID before, so I doubt it's COVID. But my throat hurts. My daughter's throat, maybe it's RSV. Hold on. No, let me not Google stuff. Let's get up, but my throat definitely hurts. All right, so we are picking up from last week, okay? We're picking up from last week. And this was the prosecution's motion for dismissal. And before we get into Cannone's hearing, I mean, there's really nothing going on right now. There are no other trials. At least I've not seen a trial that I'm really interested in, but let me take a look. Because I don't want to start any new trials. And, just because it's almost April 1st, okay? It's almost April 1st. It looks like this Karen Reed thing is going to go. So that's why I don't want to start another trial. I'm just going to stick with what we have here. So in the meantime, I'm going to work on Karen Reed and Brian Koberger. I'll get to it eventually, you guys. I had a good weekend. I had a really good weekend. I did my usual. I did my laundry, folded, cleaned up. I did my hair. I did my daughter's hair. I read a lot, so that was a productive weekend. So yeah, we're not starting a new trial right now. We're just gonna focus on Karen Reed, and then I guess we get into Trooper Proctor. That's really what we're supposed to be doing. But I also want to get into the dog bite stuff because here's a question: when I was going over this in preparation for today's live stream, right? I'm trying to figure out why folks want to deprive the prosecution of a dog bite expert, yet Dr. Russell is supposedly qualified to testify. I don't understand that from, I don't understand that from the layperson's perspective, but and instead of reading Cannone's decision, I think it makes sense to watch the actual hearing so I can make up my mind for myself. But let's get into Jackson. I believe it was Jason or Brooklyn. I think it was Jason that says this is the good part.
Your Honor?
Yes.
Thank you. We're going to address in reverse order some of the statements made by Mr. Brennan. And I want to talk first about this issue of juror interference, which is what we called it. It's words matter. We've claimed that there's interference. He indicates that that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts that he very dramatically stated in just a second, because this is a fact-based inquiry, one that we asked for standing right over there at sidebar and didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None, zero. And he knows that. But in an effort to create an enemy where there isn't one, he acts like we've insulted the court officers, which we haven't. He also said,
Hold on, I need to go back. I got
that Lieutenant
distracted.
Van-
I was reading emails. Excuse me.
zero. The populating.
Oh, and I figured out my schedule. So my schedule will be Monday to Thursday, but if there's a trial, then it's probably Monday to Friday or Monday to Thursday and Saturday. We'll just figure it out. But that's my schedule. I like my weekends, okay?
This courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None, zero. And he knows that. But in an effort to create an enemy where there isn't one, he acts like we've insulted the court officers, which we haven't.
Okay.
He also said that Lieutenant Fanning stood up here and gave basically a CV, a resume for him, and said, the greatest guy on the face of the earth.
He did say that.
I don't know
Something
Lieutenant Fanning.
close to it.
I don't know if he knows Lieutenant Fanning. Not really the point. It's in the personality contest. He said that we identified somebody with an unassailable reputation. We identified him. We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen when somebody else identified him. Wasn't us. And by the way, everything that we filed concerning this was under seal. We didn't disclose anything in any court document. It wasn't a public document, it was under seal.
So who did?
Mr. Brennan then states that he was also a subject, this person with this unassailed career, was the subject of an IA investigation for his conduct on this case. It's not even about something tangential. It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor and his, and I'll repeat it, disgusting conduct as it relates to my client and his text message.
Michael Proctor, sheesh. Again, I've thought about it over and over again. I do not know how the prosecution recovers from Michael Proctor. I don't know if they call him. I don't know if they decide not to call him. But Proctor's definitely, I don't know. But that's hopefully it's a lesson learned, right? For folks in the what is this, the sheriff's office and the county that they're in.
Messages, etc. When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer. We've seen that happen before. The question, or questions, if I could, that surround this inquiry, and the reason that we included it in our motion to dismiss is because it appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified to this day unidentified, how would this person know who the juror sitting in one of these seats was if she was at a private location? I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things? How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people, who was then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course, it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's a commander over operations that are attendant to the courts, the actual court's security, the personnel's security, the party's security to whatever degree that is necessitated, but maybe most importantly, the jurors' security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given. But we do know this. He was this same Fanning that was just randomly picked to go report this to, was also the person that was in Ms. Reed's house seizing her phone just months before the trial. He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial. He was also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that existed. And yet we were denied an opportunity, Your Honor, an important opportunity to simply inquire before this juror was dismissed. That's all we asked. Let's get Lieutenant Fanning in here. Let's find out what the source of this is, and let's figure out, is it even remotely true? Remember, the juror never said it was true. But lo and behold, minutes before I stood up to give my summation, that juror's removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about.
I know Old Bag said.
This is about what happened at sidebar in the matter
Old
of.
Bag sent me an email after not yesterday. I was not live yesterday. Last week's live stream, and she said apparently she liked Jackson's argument.
And it's that denied Ms. Reed her constitutional right. There's a couple of other points that I just want to make. Mr. Brennan started his comments by talking about the Sallyport video and how unimportant it is. How unimportant that video is. And I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull Sallyport videos if you're investigating a bar fight. This was the purported murder weapon. This truck is the thing that the Commonwealth suggests was used to kill a cop. You think the video of it being pulled into the Sallyport might be of some evidentiary value? I don't know. Can't imagine why that would be important. Can't imagine why that might have some evidentiary materiality. But I do know this. I do know this much. The one guy who thought it was important, the lead investigator, he pulled it all of it. He was super convinced it was important. And he's the guy that once pulled it, hid it from us for nearly 3 years. Mr. Brennan spent some time talking about the difference between cracked and missing. Interesting point. And I'm not going to go through a bunch of videos and audios. The court has seen all the pictures and photographs that it needs to see, and the court has a very, very good memory. We've never, ever disputed that the light was cracked.
Okay.
5:07 or so a.m. That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at or near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety, almost, except a piece was still missing. There was a piece unaccounted for. There's a big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant and it's exculpatory. The condition of that light when it pulled into the Sallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Buchnick,
Lally was not a good attorney,
present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page in sight now, but I remember it because I was sitting there. He asked the question, did you see Mr. Proctor? It was something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Trooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played? Is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of
I
that.
don't think I have. Sure. We can get that for the court immediately. Also, he played a video of the grainy video showing, hey, look, some of these cameras are just grainy in other particulars as well at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, if my memory serves me, and it's my memory and it's being taxed at this point, but my memory is that the Cannone on that video, in other words, the running numbers, was at the bottom.
It was what?
That video he just played is at the top. That's the exact same video. If it's apples and apples, oranges and oranges. Why is that different? That's interesting. And with regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the Sallyport. With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing. Why is the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should,
Okay.
the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot, it's
Okay, what just happened? What on earth? Okay, come on, Court TV. I guess they lost, though. We lost Jackson.
That it was.
Okay, this is the part. This is actually what I'm interested in. Okay. I wanted to hear Yannetti's response as far as, his knowledge of who is in charge of the jurors. Okay. This is what I'm really
That I stood up in rebuttal and said that it was in court advocating for my client. He then said Court TV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a Court TV site on that. Is
Right.
there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yannetti is referring to that comment that was a court comment. And so I intend on remedying that record. There was also a conversation after with Court TV.
All right, so provide it to Mr. Yannetti. Mr. Yannetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me what you want to tell me now.
Right now, it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it. And he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no Court TV interview where I said anything of the sort. That was a Zoom hearing, where I was arguing.
She's loving it. Karen Reed's mom is loving it.
And
that's always been an expression.
I would just note, Your Honor, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable. But it's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds, that
You can take your time, Mr. Yannetti. You're not going to be
we're all
45 minutes.
Right. I certainly will not be. This new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one. But I think perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
I certainly do. So, Mr. Brennan, if you do not have a site,
I missed a lot of, I guess, because they lost signal.
then I need you to let us all know that as well.
A lot of.
I will. It's convenient to retort that there were 10 lies by the court that Mr. Alessi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly were just wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related Ms. Yannetti's remarks, it wasn't in relation to 3.6. It was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide.
For your request for the gag order? In support of your argument for the gag order?
In response to how they had used federal materials that were under seal that couldn't be rebutted to make suggestions. It's directly related to that point, not 3.6. But I will provide the videos. Mr. Yannetti is right, and the exact statement that I used was from a court hearing, but then there were subsequent statements made. And so my regrets to Attorney Yannetti, but it wasn't in the fashion of a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials before the case was closed to their advantage.
All right. So if you have the site, I'll give you until tomorrow afternoon to find the Court TV site.
Very well.
If you have it, supply it to all, Mr.
Take it
Netti.
down.
So I'm ordering the Commonwealth, if they have that Court TV site, to provide it to all of us. And if you don't, provide that as well. Provide that
Very much appreciate
information.
it.
as
Thank
well.
you.
Thank you. All right, that's it for today.
I believe they go back the 14th, no 18th. I'm sorry. In any event, that's not as eventful as I was hoping it to be. I was gonna wait to go back to day one because I believe I don't want to read these comments, but I'm gonna do it anyways.
Can you throw that up on the ceiling for me?
Yes,
All right.
making sure.
Let's go back. I know we're doing it in reverse order. I'd actually lost my timestamp. What's up, Benji? I'd lost my timestamp because we had done part of day one. I just do not recall how far we got. Benji, did you have a good weekend? How's your weekend?
Sure thing.
I appreciate it.
It takes forever. Yeah, I'm trying to figure out because we have like 30 minutes. My throat hurts, you guys. I hope I don't have COVID, but my throat really hurts. So I'll give it another 30 minutes and then I'm going to call it a night and we'll start over tomorrow. I'm just trying to think as far as I'm going to have to retitle this video. Let me think. I'm going to take 5 minutes to think. Let me think.
Tap the red one.
Okay, what's going on?
Tenants, Michelle, be heard. God save the Commonwealth of Massachusetts.
All right. So let's move on to the next motion.
Your Honor, if I could, the tabs that I had, I've
I
marked them
like
as
this defense
exhibit.
attorney.
Personally, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had two.
Okay, we're not going to
address in
listen
its
to that again.
presentation. You heard one probative, legal, or factual point I made because they can't specifically. The Commonwealth just stated that Dr. Crosby has testified in court numerous times.
On page 6 and 7, Dr. Crosby offers court cases in which he has testified and provided expert opinion.
Okay, the only reason I'm going back here is because I just want to understand exactly what the parties argued before getting into Cannone's decision, okay? Because again, some folks were of the opinion, or at least the advocates and supporters of the one and only Karen Reed, they are of the opinion that the prosecution's dog bite expert should not be allowed to testify. So apparently it sounds like they are of the opinion that Russell is qualified to testify and Crosby is not. But if I recall correctly, I think Crosby only gets called to rebut Russell's testimony. Okay, Benji said, yeah, it was good. I was hanging out with friends. We played some video games and went to get some food. Okay. That sounds good. I had a good weekend, Benji. I got to read. I did my laundry. I folded my laundry. I cleaned up. I washed my hair. I took my kids swimming. I could have done more. The time change messed up my schedule. I did not get enough sleep last night, but that's also because I was on the phone with my sisters for a long time. Yeah, I don't know. The time change messed up my schedule a little bit. Maybe I get it right tonight. I don't know. We'll see. We'll see.
Give you
Thanks for asking.
specific cases where he's been qualified in state and federal court. Mr. Lisi harps on the idea of methodology. If we remember Dr. Russell's testimony, it wasn't until later in her testimony that she introduced this idea of pattern recognition analysis. And we hear very little about the details. What we knew or learned from Dr. Russell is that she couldn't identify any of the wounds, none of them independently, just collectively. In fact, I think she opined that she was the only expert in the country that really could
Right, she did say that.
perfect the art of pattern recognition analysis. Attorney Alisi's arguments are the fact that he doesn't like the way Dr. Crosby wrote his report. But what I can say for Dr. Crosby is at least he wrote his own report.
Woo!
And when you look at
Hold on.
Dr. Russell's affidavit in support,
I'm sorry. Wait, what? He's a witty. I think that's what I like about Brandon. That's what I
are the
like.
fact that he doesn't like the way Dr. Crosby wrote his report. But what I can say for Dr. Crosby is at least he wrote his own report. And when you look at Dr. Russell's
Dang, what is going on with Karen Reed's mother? Like, what's
affidavit in
going
support,
on?
there's something, to be intellectually honest about it, striking. Kind of like her original report, where it was clear to me that it wasn't fully written by Dr. Russell. You look at that affidavit, it is not consistent with the testimony or the mannerism or the way that expert speaks. And so a lawyer can craft an affidavit and help craft a report so it meets their idiosyncrasies, but that is not the arbiter of somebody's qualified. Dr. Crosby is qualified, he has experience, he's testified and been accepted by courts before. Thank you.
Okay, so before we move on to the next motion, it was filed after the other motions that we finished here. It was filed on February 21st, I believe. Defense motion to exclude, February 21st. Defense motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative, Douglas hearing. So the last time we were here, I wasn't sure we would reach this. I think it had just been filed. So I don't have an opposition
You're kind of late, Benji. This is a completely different week, okay?
from the Commonwealth. I don't know if you.
But I mean, you're pretty young, so I understand. When I was in college, I was young. Back in the day, I was the type of person that would wear all my clothes. I used to have a lot of clothes back then. I still kind of have a lot of clothes, but I could go like 4 or 5 months wearing completely different clothes without doing laundry. And then it came to a point where I have nothing to wear, and that's when I did laundry. Yeah, I was a little, I don't know, very, very chaotic back then, but I was young and dumb, so that's my excuse.
Wrote one, if you planned on writing one, or if you just wanted to go forward, and also whether you're prepared to go forward to it.
We do not have a written opposition, but we are prepared to go forward today.
Okay, so I will hear you, Mr. Leslie, this is you again, right?
It is, Your Honor.
All right, so I'll hear you.
As we get into the trial, right, I'm curious to find out what Alessi's role is going to be, just in terms of, the division of labor, right? Because I absolutely enjoy Alessi and Brandon going at it. They're my favorite attorneys to watch in this trial.
And this is paper 515.
They both look like they're well read.
May it please the court,
Relatable.
Mr. Gilman, a meteorologist, is attempting to opine on the hardness of soil conditions at 34 Fairview on January 29th, early morning 2022. He states in what is a certified weather statement, that's quote, certified weather statement, many things, and we don't challenge his statements about what the temperature was and precipitation. But what we do challenge is his opinion with regard to the hardness of the ground. With regard to his qualifications, his qualifications to opine on the hardness of the ground. He is not a geologist.
Yeah, I guess I don't know. I guess we'll find out. We'll find out what happens with that. I'm trying not to get involved in Turtle Boy stuff because again, I just want to stick to the law, okay? Because I believe it was the YSL trial. Uh, they recommend Granny's videos to me, okay? And I see she had a live stream about somebody else being back in custody. I'm like, whatever. People should live their lives the way they want to live their lives. So I don't want to get caught up in that stuff, following things that. But I do like talking about Mr. Bumpus though, because I still cannot believe that. I don't know. Let me move on.
He's not a pedologist, i.e. a soil scientist. There's a specific field for that. He's not a hydrogeologist, which is a scientific discipline that blends water movement in the subsurface, particularly the soil. He's not a hydrologist, which deals with solely movement of water, whether it's in any kind of media, soil, etc. And he doesn't purport to have any of those qualifications. He doesn't even state that he took courses in college that would have even educated him on soil hardness and the effect of precipitation with regard to the hardness of the ground. But perhaps the most telling statement that he makes is he puts his opinion in quotes. So his certified weather statement is hard as a rock, I believe. I'm looking for it.
So I'm sorry, there were a couple of exhibits attached to your affidavit, Mr. Leslie.
Yes.
All right, so one's exhibit 1, I don't see any.
I'm sorry, Your Honor, it's Exhibit 1.
Okay.
It's his February 3rd, 2025, quote, certified weather statement.
Okay.
That is it. And at the bottom of it, it's got in the quotes, the
Okay, I see it. All right, I don't see anything that says certified weather statement. It's an email, right?
no, his report is exhibit, well, it does state certified, and I'm quoting certified weather statement.
Is it NDA 02802 and 803?
It is exactly that.
Okay.
Yes. So Your Honor, he puts his opinion in quotes, which to me is an indication he's speaking in lay terms. I've never seen an expert put an opinion in quotes.
Okay.
And he does not tether that opinion to any methodology. As a matter of fact, Your Honor, and that's the entire basis for what the Commonwealth is proffering is support that one, he's qualified, and two, that his methodology is reliable, but he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is. He doesn't say how he came to that conclusion. So it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence. They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion, in quotes. And Your Honor, there is a deep and typical of science, complex way to determine hardness of ground. And he doesn't even begin to discuss that whole science.
What's up, Jerome?
And Your Honor may recall in previous Delbert Lanigan hearings, I cited to the Goodman case, the Pasteur case, And the courts in Massachusetts has said, in addition to going through
All right.
making
So
sure you've got a methodology.
I know that I had said, actually, let's just get into this. All right. I'm going to do something. No, but if I do that, I might regret it. Let me first do it I'm going to do it in the background because, again, I don't want to leak my actual email. So hold on. Wait,
The court can
I found something really interesting.
also use it's the words of the court's common sense.
Right.
So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. What is the weather? We all know what it is. I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I've never heard it, because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells one that this is not the kin of meteorologists. And interestingly, the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor, he's not qualified in this area. He doesn't even state a methodology to come to the opinion, let alone show that if he had a methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using layman like an idiom, a term that people just use. You know, his head's as hard as a rock, whatever. But that's not science.
Okay.
And in order to give an opinion to the jury, the whole purpose of general acceptance, the whole purpose of Daubert, is it has to be based in science, and it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor, Mr. Gilman, the meteorologist, should never reach a jury to talk about hardness of the ground.
Thank you. Mr. Brennan, first question, do you intend to call this witness in your case in chief or for rebuttal?
I do, case in chief.
Right, I'll hear you.
Thank you.
The Commonwealth proposes calling this gentleman to talk about the weather conditions leading up to the night that John O'Keefe was killed.
Okay.
Talk about the temperatures, the wind conditions, also the snowfall. It seems that the only complaint the defense has is the ultimate opinion that the ground at Fairview was hard as a rock. I think that concern is easily remedied. I do not need to ask this expert if the ground at Fairview was hard as a rock. I can ask him about the documented temperatures, the winds, the snowfall, what makes the definition of a blizzard, how many hours have to elapse in certain conditions to be a blizzard. Also, he can measure the snowfall as it accumulated that night into the early morning hours because there's statistical evidence about it. And I would like him to talk about how ground freezes. Without giving an opinion that this ground was hard as a rock, he should be able to testify that over a period of time, the frost below freezes the ground. I don't need or would not ask Mr. Gilman to talk about the ground hard as a rock. We have a handful of first responders who will give lay opinions with common sense that the ground was hard as a rock, and state police who excavated can testify to that very thing. So Mr. Gilman.
I don't know. Again, I don't know if it's sarcasm or it's generally just how he speaks, but Brennan to me is really entertaining.
Not need to offer that opinion. If that's the only thing offending the defense, I think we can resolve the issue.
Okay. Would you say that, Mr. Lessing?
I like these two. Like they're going at it, but no personal attacks.
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned, but its proposal to have a meteorologist talk about how ground freezes is still very much problematic because, just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that. Benjamin J.G., 2005, freeze-thaw effects on penetrometer resistance in shear strength.
Why don't you put those in right now? Was that just a Google search? I saw that you had it on your.
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me. Is there any objection to the Commonwealth to me getting that?
Not at all.
No.
Happy to provide it, Your Honor.
Do you want to provide a copy to Commonwealth as well?
I'd be pleased to provide a copy to the
All
Commonwealth.
right, so I'll take this under advisement. So how long do each of you need to get me what you said you would get me? The Commonwealth, the articles, and the qualifications, right? The cases and the qualifications.
Everyone's entertained.
Dr. Crosby,
I can
Yeah.
get that to you today.
great.
I definitely like, and not to say that attorneys will always see eye to eye, but I think it's two different perspectives, okay? When I am watching other attorneys, I like to see them get along, okay? But when the shoe's on the other foot and I'm the one that's advocating for a client and I feel that the attorney is not, they're not going along with the law, or they're just making it more difficult than it's supposed to, then I guess sometimes. But I've come a long way. I'm much calmer now. Okay, 10 years ago, maybe 11 or 12, I don't know. However, I did not have a kid then. So yeah, I think 12 years ago I was a hot mess. I was like really, really, really hot-headed, but I quickly got out of that.
And those articles, Mr. Alessi, that you were just citing, when can I get those?
Do you want all the citations or the articles?
If you've got the articles, if you've got a copy that'll save me from having to find them and read them, that's fine. If you just give me the links, I can do that myself.
I'll get you the articles, Your Honor, in the text, and it's probably going to take you 2 or 3 days.
Do you have the links? Do you have a list?
I've got a list right with me today.
Okay, so I'll take that. And that'll save you from having to print the articles.
You let me hand it to the court officer?
That would be great. And you'll provide it to the Commonwealth as well. Is that your only copy, Mr. Alessi? Do co-counsel have copies?
Oh, no, co-counsel doesn't have any of this, Your Honor.
Why not?
I just need to black out
Co-counsel,
something here.
sorry, I thought-
You don't have to do it right now. Do it before you leave.
I'll do it before I leave, Your
And
Honor.
that way
Thank you.
there, we'll see to it, Jim, can you get a copy made for everybody? Thank you. All right, so now, because we're doing them in the order they came in, Commonwealth's motion to impose sanctions.
Oh,
This involves a transcript that I've read, I've listened
well, I believe this is what Yannetti was responding to.
to the actual recording. Maybe it makes sense to take a 15, 20-minute recess. Now, does that make sense to everyone? Okay.
All right, good morning, please.
Is the Commonwealth going to play portions of this or not? The flash drive has been impounded because I understand the nature of it. Is it all, are you referencing just the transcript? Actually, we're gonna see Councilman.
My fan's always going. It's lengthy.
So the next motion we have is the Commonwealth's motion to impose sanctions pursuant to Mass Work Criminal Procedure 48. Mr. Leslie, do you need a minute? Did you need a minute? I saw you just.
Could I please just?
Sure.
Thank you.
Timmy?
Yes, I'm working on something.
Why don't I take a 5 minutes?
All right, please.
What's going on?
Brennan, I will hear you on this motion.
My throat hurts, you guys, so I'll be back tomorrow, though. Jerome was apparently super hot-headed back in the day as well. I mean, it happens to the best of us. Benji says, okay, so Benji's hot-headed from time to time. I guess you are around that age, Benji. Only after 20. That's when an individual's brain is fully formed. So, yeah. All right, let's get into this. But my throat's on fire. It's on fire. This Proctor? No. Hold on. Something else. Okay.
As the court's aware, there are certain materials.
I'm sorry. I like. I don't know if it's his cadence. There's something about the way Brandon talks. Let's get. I don't know. He always sounds like he's reading a script.
As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred. If there was no need for protective order, there wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule Criminal Procedure 48, the court can impose sanctions. In this instance,
Oh, I messed up the audio. I'm sorry. Can you hear me now? I should leave this mic alone. I do not know I try not to talk about Donald Trump, but I cannot help myself. I don't know what Donald Trump has on, but I just hope that I don't lose my pension. Okay. I really have no idea what he has going. He also has no idea what he has going on. But I'm kind of getting worried now. I probably should have withdrawn all my stuff before he was inaugurated, but I'm getting concerned.
that was the genesis for this motion. There was recently provided materials that the court ordered the defense not to disclose to the public.
Okay.
Those materials, which is some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order. Now, it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, given the history of this case, it is important to make sure that these type of violations don't happen again. What stands out to me in the reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information. In the memorandum, page 9, what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial.
What's going on?
There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness,
who was not bound by a sequestration order at the time of closing, didn't want to watch a closing, there is no good faith basis whatsoever that that witness watched other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information of the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of the jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court. It's unfair to the people of the Commonwealth. It's unfair to the Commonwealth. It's unfair to the prospective jurors. And so not only is there a
Brooklyn does not like liberals. Brooklyn said no politics. Okay. Yeah, I don't know. I need to stop moving it. I need to stop moving it around. I don't know, Jerome. I have no idea. I don't know. We'll see. I don't want to lose
really
my money.
not a logical or a reasonable basis to put this information in, but when we look at the nature of the information,
Brooklyn's so funny.
it becomes clear. And so we turned over this information 3 times. We did turn it over as a text message, and notice of discovery 51, a protective order was issued, docket 416.
How
We
much
produced
longer?
it, notice of discovery 57. And again, there was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some
Was
of
that
the materials.
Cannone?
It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online. And it seems that was the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position.
Nah.
We've had a history in this.
Politics affect literally each and every single aspect of our lives. So no, I cannot. I tried not to talk about Donald Trump, but I cannot help but talk about Donald Trump. So, I mean, electricity is about to be out of reach for folks in New York and 2 other states. So we have to talk about them.
This case that predated me, docket 111, docket 262, where there have been efforts by the.
I can't even afford eggs, you guys. So I have to talk about them. I went to Dollar Tree for the first time in months. Dollar Tree, they were selling Easter baskets for $5. It's Dollar Tree. So no,
Commonwealth
that has nothing to do with Trump, though.
to stop, prevent extrajudicial statements. And despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop.
Why don't you
Rule
tell me, Brooklyn?
3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation of a
My money cannot afford a recession. Okay, Jerome, I cannot afford a recession right now.
matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications
let's
and will
get
have
to
a
your Nettie.
substantial like.
want to see how
As
he
I mentioned
starts
at
off.
sidebar, I intend to make, Your Honor, as I mentioned at sidebar, I intend to make less of an argument here and provide more of an explanation for the content of my motion regarding the reciprocal discovery. And at the outset, as I mentioned in court last week, this was indeed my motion. Mr. Jackson's name is listed first only because I used a template for the signature block, and that's why I'm.
Yeah, Dollar Tree is getting a little outrageous. I mean, the baskets were nice though. They were the little peep baskets, so I had to. I don't know. I went in Dollar Tree to buy a single thing. Okay, the only thing I had to do in Dollar Tree was get an envelope because I have returns to make, and I needed something to pack them in. That's all I had to do. But I started. I don't know. My eyes started looking at other things I don't
Addressing
need.
this today. And regarding the motion itself, I do acknowledge that I did not file a motion for impoundment when it was.
Brooklyn, I don't want no goddamn stimulus money. I want my pension. That's what I need. I need to be able to retire. A $200, $300 stimulus check is not going to do us any good. We need a what's the point? If he tanks the economy, what the hell is a little $200, a little $300 going to do for everybody? No, 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 no. We want our money. We want stability.
Filed. And to the extent that that lack of impoundment is not
That's
congruous with
crazy.
the protective order, it was neither.
Jerome, I cannot afford a recession. I have a few. What month is this? This is March. I'm supposed to be about 10, 11 months away. No, it's 10. Are my numbers off or is it 9? I don't know. I'm supposed to be 9 or 10 months away from going out on my own. I cannot. Recession? No, 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 no. Not in my
Intentional
cards.
nor willful. It was an oversight, not an attempt to flout any rules of this court. And while I do ask the court to take my.
That's a little boring. Okay, folks, my throat really hurts, okay? Trying to force that bit. We don't want none of that Bitcoin stuff. We want real money. Okay, we want our money. We want to be able to keep and maintain our money. My throat's on fire, as I said, so I'm going to medicate myself here. I'll be back tomorrow. Hopefully tomorrow I always have good energy, okay? But tomorrow I'm going to be loud. I'm going to be loud, out of control. As always, it's just right now my throat is on fire. My throat's on fire, but I'm also under a lot of stress. I'm under a lot of stress. And no, I was not up here on Friday, but the feds hit me with a last minute filing that just changed everything. So I'm under a lot of stress because the law is not on my side. Is today your birthday? Oh, it's today. I should have written it down. Happy birthday, Brooklyn. Brooklyn, why didn't you say anything? Now I feel so bad. Okay, I'm gonna write you a personalized card. Okay. Happy birthday, Brooklyn. I'm gonna write you a personalized card. Let's sing. Hold on. Let's say happy happy birthday. Ooh, happy birthday, Brooklyn. I know that's not your name. I know your real name, but I'm not, Let's see. Let's see what they have here. Hey, 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 hey.
It's your birthday today. It's
All right,
Brooklyn. Rock, roll, let's celebrate. We lose control and you cut the cake. The night is yours. Destiny awaits. So share toast with your closest mates.
Thanks, Benji.
It's your birthday today. It's your birthday today. Grab your goodie bags.
Go on, Brooklyn.
Blow out your candles.
It's so chaotic. Did you blow out your candles or no? All right, Brooklyn. Happy birthday, Brooklyn. I'll play another one, but my voice, I need to rest my voice. I'll play you another one tomorrow, okay? Benji said, what's going on? It's Brooklyn's birthday. It's Brooklyn's birthday, so I thought that was, it was a random video. Let's do another one. Let's see. And this one looks kind of normal. We don't want normal. Let's see. It's Brooklyn's birthday. I don't know. Let's see what's going on here. This looks chaotic.
Brooklyn. 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 Hey, Brooklyn!
That's not even his real name.
Happy birthday, Brooklyn.
Oh, this is called Angry Birthday. Got it. That's actually a pretty cool concept for a channel, right? I think that's like an angry. Let's see. That was fantastic. I like the first one though. I hope you had I hope you had a fantastic birthday, my friend. It's only what? You still have time. It's like 9:41. Okay, so you guys are going out of town. Okay. All right. Have a fantastic birthday. And I'd send you $5, okay? I'll send you $5. Send me your Cash App. I don't have Cash App actually, but I can Venmo you. Okay? Send me your Venmo. I'll send you. I don't know. I'm trying to look around here. Let me see if I have. I'm gonna look around for. I don't know. I don't know that I have any more gift cards. I don't know that I have any more gift cards, but I'm gonna write this down, okay? So March 10th. It is Brooklyn's birthday, okay? All right. Then we also have Jerome's birthday. That was February. Benji, when is your birthday? You don't have to tell me, but you don't have to tell me. All right. Okay, folks, I'm gonna call it. Okay, so Jerome wants me to play it one more time. All right, let me play it one more time. I'm gonna play it one more time. Wait, the first one, right? Because the first one, I actually like the first one. Or did you want the second one? I'm gonna play the first one. All right.
It's your birthday today. Brooklyn!
It's your
It's your birthday today. Brooklyn! Rock, roll, and celebrate. We lose control and you couldn't get
right.
The night is yours. Destiny awaits. So share toast with your closest
September 8th.
mates.
All right.
It's your birthday today. Brooklyn! It's your birthday today. Brooklyn!
All right, Brooklyn.
Open your gifts. Blow out your candles. Brooklyn!
All right, Brooklyn. All right. It's your birthday today, Brooklyn. Oh, I hope you had a fantastic day. I'll send you a personalized card. I don't know that it's tonight, because I need to take care of my throat. But I'm gonna send you a personalized card, okay? That's what I'm gonna do. And then I've written down your birthday. Benji, I've written down your birthday. I think Benji's birthday is actually going to be easy to remember because that's the day before my little cousin's birthday. And it's also the day before one of the other paralegals I used to work with. I only know the paralegal's birthday because it's the same day as my little cousin. So There we go. It's actually my second cousin because I think it's my cousin's kid, or is it my first cousin once removed? I don't know. She's related to me. So, all right. All right, folks. And we do love you, Brooklyn. Okay. I am honored that you came up here to celebrate. I mean, it's your birthday, but you still showed up. You still showed up. Well, I hope you have a fantastic day. Enjoy what's left of your day and be on the lookout for that personalized card from me. All right. I know that I'm going to do it tonight because once I close this laptop, it's closed. Okay. It's closed. So, but I'll send you a personalized card. All right. It might be. No, I'm going to do it tonight. Okay. Let me go. Let me go because I'm like 15 minutes over. Let me do it. I'm going to do it before I call my man. All right. Okay. All right, folks, we will be live tomorrow. Tomorrow, let's get started on. Now, no, I probably need to rename this video because we still have to get into that decision. We're going to have to get into Bev's decision for the dog bite expert. But from my perspective, just being neutral, I do not quite understand. I guess I probably have to read the motions themselves, okay? In any event, tomorrow we'll be live. Tomorrow we are going to start off with we need to get into Proctor a little bit because Proctor is really he is a fixture in this trial, whether he wants to be a fixture or not. And actually, I think here's what the defense needs to do, okay? The defense needs to borrow from what is this? They need to borrow from Colin Griffith, but they also need to borrow from O.J. Simpson. Okay, the O.J. Simpson trial. I do not remember the name of the investigator or the detective. I'm gonna have to find it. Okay, but the defense in that case centered primarily on that one witness. Okay. So I think that's pretty much what the defense should do. That's what they should have done in the first trial. Made it all about Proctor and take the shift away from the defendant in this case. But that said, so tomorrow, let's start off with Proctor. Okay. Let's start off with Proctor and then we take it from there. All right, folks. I ramble a lot. I need to go. Okay. What are you saying, Jerome? Jerome, you should have come up here and sung "Happy Birthday." Like you should have. Listen. So tomorrow, I'm gonna start off with that "Happy Birthday, Brooklyn," or maybe somewhere in the middle. And Benji, if you're not at work, Jerome, if you don't have other things going on, let's come up here and sing for Brooklyn because we all know the song now. Okay, I need to go, you guys. I need to go. My throat is on fire. So, you guys have a fantastic Tuesday. I'll try not to be as stressed out again. I had a last minute demotion not motion, it's a filing from defense. It threw me for a loop. I have a hearing on Wednesday. I'm trying not to be stressed out. I woke up really early on Saturday, okay? Woke up really early on Saturday trying to figure out how I was going to argue this thing. The case law is not on my side. It's not on my side, but I have to figure something out. All right, folks, I'll see you tomorrow. Bye.